This is an exposure of an operation of law that Canada has worked so hard to hide from the public and from individuals. Looking at a court judgment here, Gerald Mitchell, January 2014, the administration of justice. The central concern of Section 24 of the Charter would appear to be the maintenance. Now remember that word, maintenance of respect and confidence in the administration of justice, as that may be affected by the violation of constitutional rights. According to Grant, the term administration of justice in Section 24 concerns maintaining, it's twice they use that word, right? Maintaining the rule of law and its processes, and includes upholding charter rights in the justice system as a whole. The term administration of justice means maintaining the rule of law, abiding by the rule of law, allowing the rule of law to operate, not restricting the rule of law and its processes. And this maintenance of the rule of law includes upholding charter rights. That's what the administration of justice means. The Constitution Act of 1867, Article 92. In each province, the legislator may exclusively make laws in relation to matters coming within the classes of subjects next hereafter enumerated. That is to say, Article 14, the administration of justice in the province, including the Constitution, maintenance, and organization of provincial courts, both civil and criminal jurisdiction, and including procedure in civil matters in those courts. So the Constitution Act of 1867, Article 92, subsection 14, gives the provinces the right to create provincial courts, as we just saw. But those provincial courts, they are created and they operate under only two jurisdictions. It says both of civil and criminal jurisdiction. So provincial courts, the only power they have is civil and criminal. And further to that, it says including procedure in civil matters in those courts. So the rules of the court, the rules of civil procedure of the court, that's where it's coming from this operation of law in the Constitution Act. And the provincial courts, which operate only under civil jurisdiction and only under criminal jurisdiction, are coming from this operation of law. We just saw in the court judgment, right, that the term the administration of justice is a maintenance concerning the rule of law and upholding charter rights. And here Article 14 says the administration of justice in the province, including the Constitution, maintenance. The Constitution and maintenance of what? Well, the administration of justice. The maintenance of the administration of justice. The maintenance concerning the rule of law is being brought forth here. But not only this application. Secondarily to that, the organization of provincial courts would deal with civil and criminal jurisdiction only. When you're operating under an absolute non-derogable right, this is not a civil right. This is not a criminal matter. Therefore, you do not fit into the provincial courts because the provincial courts only operate under civil law and criminal law. And those court rules that apply in these provincial courts under civil matters, oh, you got to use a certain font, got to use a certain colored page, got to provide this book and that book, got to follow the rules of the court. Well, they don't apply to anything but those who are involved in civil matters, not in absolute rights, not in non-derogable rights. So what I'm trying to get you to see here is by the very definition contained within the Constitution Act Article 14, these provincial courts only operate under civil and criminal jurisdiction. And that's not the jurisdiction that someone who is enforcing the rule of law under an absolute right is looking for. The Constitution Act 1867, Article 101. The Parliament of Canada may, notwithstanding anything in this act, from time to time, provide for the constitution, maintenance, and organization of a General Court of Appeal for Canada, and for the establishment of any additional courts for the better administration of laws of Canada. So when it's written here, the administration of the laws of Canada, does that just mean domestic law? Does that just mean statutory law that they create? The laws of the legislator? Or does that open to all laws of Canada? And if it's all the laws of Canada, then through the Constitution Act of 1982, Article 26, the laws that are in international law flow into the laws of Canada. And we understand that already, right? Because we know that there's a legal obligation upon Canada to ensure those rights, to create measures for those rights to be exercisable in Canada. So they are by incorporation considered laws of Canada. And again, that's why Article 26 allows you to call on them. So in this article, when it says the establishment of any additional courts for the better administration of the laws of Canada, it includes our absolute non-derogable rights that flow from the international order. And here it's written, any additional courts. And some might see that word court, right? And automatically assume and automatically think of a courtroom where a judge sits, like a criminal court or a provincial court or a municipal court. But that's not what it says, right? That's just our understanding of what court is. And we are applying it to the definition here. But it doesn't tell us that. If we add that, then we're adding an imposition to the word based on our own prejudice and understanding of the word. But what we need to note is that it does indeed state that they can establish, which means create, additional courts, and these courts operate for the better administration of the laws of Canada. And those laws of Canada include respecting the rule of law and the principles of justice. And those laws of Canada include international order. The Vienna Convention on the Laws of Treaties between States and International Organizations, Article 27, Internal Law of States, Rules of Internal Organizations and Observance of Treaties. A state party, meaning Canada, to a treaty may not invoke the provisions of its internal law, its domestic law, its statutory law, as justification for its failure to perform the treaty. So we see very clearly it is the international order that is the hierarchy in this relationship. Wrongful Acts of the State, 2001, Article 12. There is a breach of an international obligation by a state when an act of the state is not in conformity with what is required of it by that obligation, regardless of its origin or character. So the state is in breach of its obligation if it places limitations and abridgments against an absolute non-derogable, an inalienable right, if they place a limitation against those rights, then they are in breach of their international obligation. And they cannot point to their internal domestic laws. They cannot point to statutory laws that the legislators created to justify or give an excuse as to why they are placing a limitation upon your absolute right. Article 14. Extension in time of the breach of an international obligation. The breach of an international obligation by an act of the state not having a continuing character occurs at the moment when the act is performed, even if its effects continue. The breach of an international obligation by an act of the state having a continuing character extends over the entire period during which the act continues and remains not in conformity with the international obligation. So the minute that you catch the state party breaching the rule of law, that's the minute the accountability kicks in. And when you notify them, and if you contact them, and they refuse to redress and make remedy, well, then it's an ongoing violation on their part. They are disobeying international order, and they are legally obligated to stop their actions. They are now breaching the rule of law and the principles of justice by placing a limitation upon an absolute non-derogable right, upon an inalienable right. Then they are against international order. They have breached the rule of law, and they must be held accountable because they have a legal obligation for the maintenance and the respect towards the rule of law. And no internal law, no domestic law that they create produces a justification for them or an excuse for them as to why they have disobeyed international order. Responsibility of states for internationally wrongful acts. Article 8. The conduct of a person or group of persons shall be considered an act of the state under international law if the person or group of persons is in fact acting on the instructions of or under the direct control of the state in carrying out the conduct. So this applies to all government agent actors, all government officials, and all government officers. They are carrying out their conduct under the power of the state, on behalf of the state, whether they are CRA agents, whether they are municipal agents, whether they are police officers, it doesn't matter. Their actions are being carried out on behalf of the state. And if their actions breach the rule of law, then the state is directly responsible for their actions. And if they hire individuals to sit in the offices of the government to come against your absolute, inalienable, and non-derogable rights through their legislative and statutory actions, well, Canada is responsible. Back to the Constitution Act, Article 101. The Parliament of Canada may establish any additional courts for the better administration of the laws of Canada. And it's very clear now, right, that these laws of Canada include international obligations, include the international order. And these laws of Canada are not to take actions that limit and abridge absolute, non derogable, inalienable rights. That is the international obligation Canada is under. And we saw that provincial courts are simply courts of civil jurisdiction. and criminal jurisdiction. And now here we're learning that there can be additional courts that operate for the administration of the laws of Canada. The next question becomes, what are these additional courts and how do they fit in concerning our fundamental rights? Christie versus British Columbia. The rule of law, a fundamental principle of our Constitution, must mean at least two things. At least two things. No, it means a lot more than what the judge is about to say. But he's only going to reveal as much as he has to reveal because of this case. But the rule of law, which is a fundamental principle of our Constitution, includes the international order. That's where the rule of law comes from. And it places a legal obligation upon Canada to respect the rule of law. And within the rule of law, you find the absolute, non-derogable, inalienable rights that are allowed to function, that must be recognized, that must never have limitations or abridgments placed against them. And this operation of law and this rule of law, as declared by the court, first, that the law is supreme over officials of the government, as well as private individuals, and thereby preclusive of the influence of arbitrary power. Second, the rule of law requires, that's an obligation that they're stating, the creation and maintenance of an actual order of positive laws that preserves and embodies the more general principle of normative order. And there's that word again, maintenance. In the first jurisprudence we read, that word was quoted twice, maintenance. In the Constitution Act of 1867, Article 14, it said the maintenance, again, of the administration of justice. And here we're learning that it has to be an actual order, not just suggestive, not just spoken about, but a real operative order that respects the rule of law, that respects international order. There has to be a system in operation that a man and a woman can go to in order to have their rights enforced and respected against the state party. And we further learned that there were additional courts that were to be created to help concerning the administration of the laws of Canada. And we are standing under our natural capacity as a man or woman, and therefore we are not claiming civil rights and civil duties. So therefore we do not approach the provincial courts or the superior courts that operate solely under civil and criminal jurisdiction. But we know there is an actual order that operates concerning the maintenance and respect of our non-derogable rights. Article 24 of the Charter of Rights and Freedoms. And we talked about this a little bit in my last video, that the subject and player here of anyone includes a man or woman. Anyone whose rights or freedoms, as guaranteed by this charter, have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstance. Now it mentions a court of competent jurisdiction. And we just walked through the fact, right, that the provincial courts that have been constructed under the Constitution Act are there for civil and criminal jurisdiction only. And we're not going to complain about a civil right. We're going to complain about an absolute right, not created by statutory law, not created by domestic law, but legally obligated to be respected under domestic law. So we don't need a civil court. That's not the court of competent jurisdiction. And notice here, it doesn't mention any type of court. It doesn't say provincial. It doesn't say civil. It doesn't say superior. Just uses the word court. And again, it leaves it for you to imply, well, what court are they talking about? Court judgment, Doucet Bordeaux versus Nova Scotia. A court of competent jurisdiction is any decision maker, tribunal, or judicial officer that has the authority by statute, common law, or constitutional function to decide questions of law, apply the charter, and grant the remedy sought. So now we see the truth, right? Instead of our preconceived ideas about what a court is. A court of competent jurisdiction is not just a place where you go, like a provincial court, a municipal court, or a superior court. A court of competent jurisdiction, as described, is any decision maker, any tribunal, or any judicial officer that has the authority. So an individual can have the authority, and this authority is given to the one individual either by statute, well, we don't care about that, right? By common law, well, there you go, je commune, or by constitutional function, same thing. Constitutional function brings forth the common law, and both of these subjects bring forth absolute rights, inalienable rights, non-derogable rights, and they have the power to decide questions of law, to apply the charter, and to grant the remedy sought. So if we're not looking for a civil court, we're looking for a judicial officer in particular who has the authority under common law and under constitutional function to apply the remedy. All right, here we go. The Vienna Convention, Article 53, treaties conflicting with a peremptory. Oh, there's that word again. Remember it. Peremptory norm of general international law, which is what? Well, jus cogent, common law rights. There it is, right into international law. Peremptory, jus commun, common law. That's what it's saying. A treaty is void if at the time of its conclusion it conflicts with the peremptory norm of general international law. For the purposes of the present convention, a peremptory norm of general international law is a norm accepted and recognized by the international community of states as a whole, and as a norm from which no derogation is permitted. So there it is, all in one little article of law. It's a peremptory operation of a right. It's a common law right, and no derogation is allowed to be applied to those rights. So when you read Article 16 of the ICCPR, which says everyone, the man or the woman, has the right to be recognized before the law, it's a common law right. It's a peremptory right. No derogation can be applied against it. And the minute state law, domestic law, statutory law tries to force you into recognition, well, they're breaking Article 53. They're breaking common law. They're trying to apply a limitation to a right that is recognized under international order, of having no derogation, of having no limitation. And these common law rights, and these absolute rights, and these inalienable rights, and these non-derogable rights, they are peremptory in nature, and that means they are expected to be obeyed immediately and without any question. And if the state party fails to do so, then they are breaching international law. They are breaching their legal obligation to respect our rights. Responsibility of states for internationally wrongful acts, Article 40. Serious breaches of obligations under peremptory norms of general international law. This chapter applies to the international responsibility which is entailed by a serious breach by a state of an obligation arising where? Arising how? Coming from where? Under a peremptory norm of general international law. A breach of such an obligation is serious if it involves a gross or systemic failure by the responsible state to fulfill the obligation. So its international order is telling us that a peremptory norm that is limited or abridged is a serious obligation, a serious breach of the state's responsibility. Why? Well, because they just limited a natural right. They just limited an inalienable right, which is a common law right. And there is no operation of law. There is no principle of justice. There is no rule of law that allows them to take such actions. That's why it's considered a serious breach. And when they take such actions, then they are the ones who are against the rule of law. They are the ones who are breaching the rule of law. To place a limitation and abridgment against an absolute right is going directly against international order. And worse than that, it's going against subsequent obligations and orders that are placed upon the state party in all these international instruments that says you are not allowed to limit and abridge common law rights. You are not allowed to limit and abridge inalienable rights. You are not allowed to place limitations upon non-derogable rights. And when you do so, you are attacking peremptory rights. You owe the recognition and the obligation instantly to respect them when they are called upon. And when they fail in their duty, and when we catch them failing in their duty, then we can go to a court of competent jurisdiction. We can find that judicial officer that has the authority under common law, under constitutional function, to apply the charter and grant the remedy against the actions of the state. And who is that judicial officer? Well, that, my friends, is for a video for another day. Stay tuned.